What actually happens in those first days, weeks, and months after someone dies? Who's in charge? Who gets paid first? And what mistakes can quietly cost families thousands? Today, we're breaking it all down. Stay tuned.
Welcome to a Wiser Retirement Podcast, where we cut through the noise and bring you real, honest conversations about investing, retirement, and building lasting wealth. No sales pitches, no gimmicks, just insights to help you stop guessing and start planning your financial future.
Welcome to a Wiser Retirement Podcast. I'm Senior Financial Advisor Shauna Theriault, and today I'm joined by estate planning attorney Arun Gupta to discuss what happens next, a financial guide after death.
Hi, Shauna.
Good morning.
Good morning.
It's one of those sad topics today.
Yep.
Every time you're on, it's a sad topic.
It's sad, but it doesn't have to be. The planning side doesn't have to be sad.
True. That's why it's good to have a plan so that when something happens, it's like you can kind of just, it's still sad, but it's at least there's something to follow.
Yes.
Right?
Yes.
Well, today we're just going to look at, what happens after someone dies. Just a couple of key statistics here. 70% of Americans don't have a will.
Yeah, that kind of tracks with probably, if you kind of zoom out and think about it, obviously, my clients, I'm prepping those documents for them, but when you go through probate court.
So I guess 100% of your clients have it, right?
No, not
not until they sign the dotted line.
No, as I was going to say, and then if you lose it, and there's all kinds of complications that can come even when you have a will, maybe it's invalid, but
sure.
Generally speaking, when you go through probate and you see how many people don't have them, that tracks to me.
Yeah. So 70% of Americans don't have a will. Probate can take 6 to 12 months or longer. And then costs can reach 3 to 7% of an estate's value. So do you see probate taking 6 to 12 months on average?
I always tell clients, short answer is it depends. I'm guessing that stat's probably on a national scale. Georgia relative to other states is not that bad. I say not that bad in quotation marks, not that bad, because something that is super straightforward, maybe it'll take 5-6 weeks, but one little tiny thing that throws it off, all bets are off.
So you just do it quickly anyway. So they should call you.
Well, it's not, it's not even about the attorney sometimes. Right? Yeah, that's what I was going to say. Depends on the court too. A lot of factors.
Sure. So really, most families are figuring this out in real time. So, and often under stress and all of that. Something I like to point out is that, it's not an emergency. You don't have to rush anything.
Exactly.
I mean, if you need access to money or something like that, but it's not like you have to go and do something tomorrow.
Yes. And that's what I try and tell people, when I hear the news is this is an extremely emotional time, and it's appropriate to focus on that, the responsibility part, the paying debts, the what do I do? There's a grace period, and the law allows that also. There's sufficient time to gather that info, but immediately focusing on your feelings, I think, is probably really the most important thing. I know that's beyond just a legal opinion, but from my experience, that's at least what I try to communicate with clients.
Sometimes I feel like clients they kind of stay in the details of the after, just as like avoiding that period of time for the feelings. I know it's not obviously we're not therapists here, but I feel like, it's like, okay, what do I need to do? Because it kind of gives them a checklist of
course.
What do I need to work on so I don't have to focus on the pain right now.
And that's a coping mechanism for people, just like you're saying.
And it's busy.
And that maybe it can be a good thing, but just in terms of
what's best for you.
Yeah, exactly. Everyone handles these things differently.
But it doesn't have to be stressful, financially speaking, as long as there's a plan in place. So with that, because 70% of Americans don't have a will, about 30% of U.S. adults do have estate planning documents in place. But over 60% of families report conflict during estate settlement too. So why do you find there's a lot of conflict during the settlement?
I would think that it would be probably a little higher than that, actually.
Really?
I guess it all depends on what counts as a conflict. But usually, when someone dies, it's a highly emotional time, and you're more prone to conflict. You may be upset about something that happened 40 years ago when, mom and dad treated the other sibling better, and it all kind of comes out. And obviously when money's on the line, you'll see a lot more people feel strongly about things too.
So that's why it's so important to have everything in order, because if it's written in black and white, sometimes there's gray areas, but having a plan and having it written down so that the intentions are there is so important to help avoid those conflicts. I don't know that it does, because you still have personalities involved or things that people don't see eye to eye on. But I mean, it's very clear in the documents what's going to happen, and everything is set up properly. Then that's what should happen. Why do you think so many people avoid planning, even knowing the consequences?
It's one of the things is, hey, most of the time when you have a deadline on something, I would guess most of the time it's done right before the deadline, right? And this is the longest deadline you'll have in your life, technically speaking, and maybe
or the final deadline,
and maybe
we hope it's long.
Yes, and when you die unexpectedly, you didn't get there, right? And that's when things can get messy. So I mean, procrastination is definitely one of the things, and then another one is no one likes thinking about what happens when you die. It's overwhelming. This stuff is also, it's not intuitive. Someone may think that they've got everything set up and they just don't,
right.
Because there's a lot of things, the way assets are distributed, that may not, make a lot of sense. Someone may think, if I just put this one person in charge, they'll take all my money and give it to everyone who I want. I wrote it down. I let them know. That's not how it actually works. And there's consequences for that person, but that person may think, oh, I did what I was supposed to do. And, they're just not aware of how all of this works.
Yeah. I feel like it's one of those things that people put off. It's like, oh, I'm not, not dying today. So
yes.
you never,
no,
it's something
you
don't plan on doing, especially, being younger. Mm-hmm. But you and I have done, podcasts before. We've talked about that. It's like naming who's taking care of your children. Mm-hmm. Even if you're young, it's like, there's certain things, but I think, avoiding conflict and making sure that you have a plan in place is so important. I feel like that's the loving thing to do for your family too. So they're not left with, especially if something happens unexpectedly, and then, they're left figuring out, wait, what just happened? And they're mourning you. And now it's like, things aren't in order. I think that would be harder.
It is harder. And even when there's a, great loving relationship and something like this happens and someone dies and unknowingly didn't have everything the way they intended it to be. And then it can cause anger amongst loved ones, and they're mad at the person that's passed away, and it causes all kinds of issues. Yeah, it can get messy. And, that's the thing with this. No matter what, there's no perfect plan, because you're never going to know what the results actually are, right? You just do the best you can based on your current situation and your prediction for the future. But even if you've thought about every single scenario, I can guarantee you something is going to happen later on that you wouldn't have expected it to.
I feel like that's true with a lot of financial planning, right?
Yes.
It's like, okay, do the the taxes, the estate, all, it's like, do the best we can with what we know right now. Yes. That's why this, this industry is so amazing to me, because you never know everything. It's never the right answer. It's like, it depends on the situation and, why I fell in love with it. But I do feel like this is where an attorney, an advisor, can add so much value to help with these, because these are, to be honest with you, it's like you and I have sat in so many rooms, where loved ones were sick or someone had just recently passed away. It's a very tender moment. It's where we can actually hold their hand and walk beside them during these times. It's one of the hardest parts of my job, and I assume yours, but it's also where we can add the most value.
I agree. People want to feel cared for. And, when you have a team of people that are on the same page with you and can help guide you through these things, it's very reassuring. And at least, for me, especially when I'm in the same room with you and we're talking to a family whose loved one has just passed, and you can tell they're, obviously and appropriately they're grieving, but, at the very least, at least they know that, there are people here that can help them. Even if things are not in order, there are still ways out to make the best of what you can.
Yeah.
If you don't have a will, that doesn't necessarily mean it's doomsday. There are laws in place that control where things are going to go, and sometimes it honestly may work out just fine. You never really know.
Right. But don't leave it to chance. So,
Yes.
so immediately after someone passes away, the next steps, you get the death certificates. Usually you get 5 to 10 copies are needed or so. Most people don't, most brokerage firms or financial companies don't require originals. They just want to be able to see the Ray seal or what have you.
Yeah. And that's, I think, as time goes on with, digital scans. But I still think it's a good idea to, 5 to 10, I think is about right. That's usually what I tell clients. You can always order more. They're sometime, by mail, they can take a little bit longer to get, but you can go in person. You can have contact your attorney. They can go in person, and I can, I've obtained death certificates, same day if needed, but it's always a good idea to have those handy.
And then the notification process. So really, notifying family, I assume, just know that when you notify financial institutions, they lock up the accounts quick.
That's what those are people that they'll know when they need to know. They're going to know in time. I tell clients, don't let that be your first phone call. Don't let that be your 50th phone call. They will know when they need to know. And it can sometimes cause more issues. They can, like you said, they can freeze accounts. It can just make things a little bit harder to do. But
right.
they, in time, they will be informed.
Yeah, exactly. On average, so this is where when I'm, when you're looking at an overall balance sheet, if I see someone that has tons of accounts everywhere, just know that on average, you have to notify 10 to 15 institutions. But if you like to spread your assets all over, you're going to have to call all of those. So sometimes, simple is better.
Yeah. I mean, everyone works differently with that, right? I mean,
sure.
Personally, easier the better, the less to do. It makes sense for me. But sometimes people, they'll have their accounts titled one way or another because that's just how it's always been, even though they can consolidate. But yes, the more accounts you have, the obviously the more steps it's going to be.
Yeah. So, I mean, that can really delay things if you have multiple accounts. I mean, you can work through all of that, but, maybe helping to do that. Is there anything else that you can think of that we've experienced or even not experienced that, kind of mistakes made early that can delay any settlement or anything like that?
Well, when everything's not buttoned up in the sense of you have some accounts that have designations that haven't been updated in a long time.
Meaning beneficiary
designations. And some types of accounts like retirement accounts, life insurance policies, usually when you set those up, you submit your beneficiary designations right then and there. So usually there's probably something on file for those. And maybe you just thought when you updated your will that it all kind of takes care of it through that, but usually, more often than not, a beneficiary designation is going to supersede the terms of a will no matter what. So even if you think you did everything, maybe you didn't.
Yeah, I can think of one. So it's like, if you have everything with a spouse, it's like, to your point, married filing joint, joint tons of rights to survivorship, or, they have beneficiaries on everything except for one account.
Yeah.
That's just randomly sitting out there. Everything would have passed outside of probate by designation, beneficiary designation, or by titling. But then you just have this one account over here that has now you have to like probate a will just for that one account, something like that.
And that can happen with fancy planning or just simple beneficiary designations. If you have a trust and you make sure everything is titled to your trust or names your trust as a beneficiary, but later on, 5 years later after you died, it's discovered you had a $5,000 checking account, probate's probably going to be required for that asset.
Which is annoying because you're like, it's $5,000, which is worth it, but it's at the same time, it's going to cost money to do it. So it's like, and sometimes you see these like couple $100 accounts and it's like, well, it's not worth it to probate it. So it just sits, it's kind of like a waste. You know?
You're right. And, I think you'd mentioned that, there's a percentage of an estate that goes through fees. That's exactly what we're talking about right now. Attorneys, accountants.
Yeah.
There's a lot that goes into this, and the messier it is, the more you're probably going to end up paying to clean it all up.
Absolutely. So having everything in order is going to make it smooth and, and checked. Just because you go to an attorney who should do a button-up job and tell you exactly how to title things and how to do beneficiaries. Some of them don't, I have found, or they just give you a paper and say, do this, which is appropriate because the client has to do it. But did you actually do these things and change your beneficiaries and retitle these accounts? So making sure and checking up on it and making sure that you actually did it.
Yeah, that's the tough part because, only generally speaking, only you can update the beneficiaries on your checking account. If you have a payable on death beneficiary, an attorney or a financial advisor is not going to be able to do that for you,
they
right?
should not be able to add a beneficiary.
And you can tell someone to do something, and life happens. There's a million things on everyone's to-do list. Sometimes this stuff just gets buried, right?
Well, and
it's
sometimes what I've seen, if you have an employer and they change who they're doing their 401k through.
Yes.
And it's like, okay, you have to rename beneficiaries and you think you already did it. And they changed, their TPA, third party administrator or something. And then all of a sudden they're not on there.
That's very frustrating. And that always gives me pause because let's say the example that you said right there, it's a new custodian for retirement accounts. And you thought you had it before and you just never got around to your HR emails and you just never did it. And the new custodian's default is going to be to your estate if you don't have a beneficiary, and then it has to go through probate. Again, it can create a mess. So just checking in on these, generally speaking, simple things. Just how are my accounts titled? Do I have beneficiaries? Do I need beneficiaries? Either a conversation with your financial advisor, or if you manage your assets yourself, doing these things is important.
Mm-hmm. Absolutely.
Not all financial advice is created equal. Coming this summer, Everything Your Financial Advisor Won't Tell You. An eye-opening book that reveals what's really happening inside the financial industry and what it takes to build a plan that actually works. Because what you don't know could be costing you.
So the role of the executor. So, some people say, well, my executor can handle this and, or I'm the executor of something. What would, first of all, what I think some people don't know is that if you don't probate a will, there's no executor. There's a named executor
Correct.
in the will, but if everything is passing by beneficiary designation or by titling, your will's not being probated. The executor has no power.
Yeah, and that's right. Technically speaking, the executor is for them to actually act, they have to be certified by a probate court. They get what's called letters testamentary or letters of administration, which basically acts as a certificate that gives them the ability to transact on behalf of the estate.
And that's only given when somebody passes away, and then you take that will to the courts to get those letters, and that's when the power is evoked.
That's right.
Created.
Yes, that's right. Now, if you have a joint account and you pass away and the surviving account holder, generally speaking, it's going to default to them. You're an executor, really, that's not part of their job. It's automatically going to default to the surviving account holder.
Great point. So their responsibilities are only the assets that flow through the estate.
Yes.
So if you have a retirement account that has a beneficiary, if you have a life insurance that has a beneficiary, and if you have a joint tenant account that passes to the other person, an executor is not going to have any control over these assets. It's only what flows through the estate. That it doesn't have a beneficiary or that names the estate to go through the will.
Yes, that's right. Now, you may hear trustee, an executor, personal representative. Sometimes these terms kind of get exchanged for another, but generally speaking, yes, executor is appointed by a court. A trustee is created through either a revocable trust or a trust created under a will. Personal representatives and executors, different states have different terms for these, and someone can somewhat step into the shoes of a personal representative, even if they're not actually appointed. But yes, generally speaking, an executor has to be appointed by a court in order for them to actually have power.
Mm-hmm. And so what would you say is their responsibility and legal duty?
So they are they're supposed to distribute assets pursuant to the terms of a will, but before they can do that, there are checklist items that they have to do also. Once they're appointed by a probate court, they have to run a notice in the local paper of the county where the decedent died in that says all creditors and debtors of the estate make your claims. And then, if creditors either file a claim in court or you are notified of a claim, you're obligated to pay those claims. But there are situations where there may be more debts than there are assets. And if you pay off a claim from one creditor, but there's another creditor that may have a higher tier, technically speaking, you're putting your personally at risk for that. Now, that's why there are grace periods allowed. There's no rush to pay off creditors. You should take sufficient time to make sure you gather all of the information so you can then pay off all legal debts and then distribute assets pursuant to the terms.
So you
of
just
a will.
taught me something new. I didn't know that there was an order of what debt is more important than the other, and
Yes.
that if you're upside down, then you have to be very careful which
Yes.
one you pay.
Yes.
That's so interesting.
Yes. And I mean, most of our clients are going to have more assets than they have debts. But, we're talking the grand scheme of things. You said 70% of
Yeah.
people don't have wills. I don't know what the number is, but I would bet you that it's a good chunk where the assets of the estate technically are less than the debts that are owed. And so it can get complicated. It can get complicated.
Yeah. So, I mean, if you don't have a will and you die, it's what is good dying intestate,
Yes.
meaning without a will.
Yes.
I think I said that correctly.
Yes.
Then they name one at the courts, but you can petition as
Correct.
the heirs or the spouse to
Correct.
say, I want to be the executor,
Yes.
and the beneficiaries sign off on that. Everybody agrees this person is representing
Yes.
dad or
Yes.
mom or
Yes.
whatever.
Yes.
And so they are a fiduciary.
Yes, they are. And you die without a will. The appointed administrator, they are obligated to pay the assets of the estate according to the intestacy laws of the state where the person died. In Georgia, if there's a spouse and no kids, it all goes to the spouse. If there's a spouse and kids, the spouse and children get everything equally, except the spouse is entitled to a minimum of 1/3. If there's no spouse and kids, it goes to parents. If no parents, siblings. If no siblings, nieces and nephews, down the line. And
Yeah. So every state
yes,
has that
yes.
order of operation.
Yes, and
Okay.
they'll have different ones. That's what Georgia's is, but generally speaking, it's some form of that: spouse, kids, parents, siblings.
What do you think the time commitment is for an executor? How much time?
This is a hard question to answer, because even something that's relatively straightforward, you're still doing things, even if it's being on the phone with the bank that's on hold for a half hour. That counts as time. When things are messy and there are
Family
disputes,
dynamics.
I don't even want to know the number of
Yeah.
hours spent dealing with something, especially for estates that have been open for years and years, that may be going through litigation or potential litigation. It's hard and it's stressful, and it's tough to go through.
Yeah. And obviously name somebody you trust.
Yes.
To handle it properly.
And not everyone has that. You got to do the best you can. And there
Yeah.
are professionals
Corporates.
out there that there's fees involved with that. But yes, generally speaking, it's always good to have a trusted person, whether that's a family member, a friend, that listen, when I'm trusting you to make sure that you are doing exactly what I want pursuant to the law.
Mm-hmm. Yeah. So in talking about just probate in general, I know we've been talking about the executor and what their role is in probate in general. We've discussed this before, what it is and when it applies, but, maybe talk a little bit about what goes through probate, and what does not.
Yes. So what goes through probate, and what I tell clients, are individually titled assets that have no beneficiary on them. If you've got a checking account, you title it under your individual name, no one else is on it, there's no beneficiary, it's going to go through probate. If you've got a joint account titled with somebody else, that's not going to go through probate. It's going to default to the surviving account holder unless it's titled in a specific other way. Retirement accounts, life insurance policies, as long as they've got beneficiaries on them, the beneficiaries are going to get them. If there's no beneficiaries, then it will go through probate and it will default to the estate.
And some people name their beneficiaries, might put it to my estate, and then that will go through
then it
probate.
goes through probate. That's right.
Because
And-
if you direct it to the
That's
will
right.
or the estate, then that will go through probate.
That's right. And then real estate, again, same thing. And Georgia actually now allows transfer on death designations on real estate. That's a relatively new a new policy that they've had.
Have you had people do that yet, or do you recommend that?
I've had a couple. I haven't had to actually have it distributed yet.
Okay.
I've set them. It's been when someone's basically on their deathbed, and it was really the only asset, and it was the easiest way instead of trying to do a trust. And when things are not if there's no health concern and you've got sufficient time to plan and you want to avoid probate, usually a revocable trust is going to be your best bet to make sure that there is no probate. And most of my clients these days do use revocable trusts as their main estate planning vehicle. It wasn't always like that, but since COVID happened, as counties have grown and courts are understaffed, especially the bigger counties, Cobb, Fulton, DeKalb, probate's more of a headache than it used to be. And clients seem to like the idea of
and you have
trusts.
states like Florida. It seems like everybody
Yes.
has a revocable living trust there because this probate's just generally hard there or expensive.
Yes. So
Yeah.
Florida's their probate fees are more expensive typically than in Georgia. It takes longer. It's seen as more of a headache there. So you will see trusts commonly used in Florida more so than you will in other states.
Yeah. Yeah. So, probate's not always bad. I mean, if it's simple in like Georgia or what have you, some state, it's not always bad, but it does slow things up. If you can avoid it, that's great. And it's also public record, right?
Yeah. I whenever I talk about trust with clients, it feels like they get real hooked on the idea of using a trust and they like it. And I try and tell them, you don't have to do this. Generally speaking, they're going to prefer to. But yes, probate's not always a nightmare. I don't want people to think that it's the worst thing in the world. Yes, it can be stressful. Yes, it can be a headache. Yes, it can take time. But eventually, it'll all end up going to either where it's supposed to go pursuant to the terms of a will, or if there's no will, then by the intestacy laws of the state where that person lived. But again, you're either paying for it up front with a trust and avoiding probate later, or you're punting and your estate will be, paying the costs of it for probate. And that's more unpredictable. So I think that's another reason why clients do like trusts.
Yeah, absolutely. So just in general, how assets are distributed, meaning, wills versus trusts versus intestate succession. We've already kind of touched on that a little bit, but how assets are distributed once it's like, okay, this person passed away. I have letters of testamentary. I'm the executor.
Mm-hmm.
What's next when notifying the institutions?
So, once you've got the letters, you can let the institutions know, and you'll open up an estate account. You can do that at your local bank. If you've got a brokerage account, those can also be estate accounts, and that'll kind of be your holding account. So,
yeah, because if you have securities that say Charles Schwab, you're not going to open a bank account and try to do it that way because then you'd have to sell everything, move it. You want to
in kind, yeah.
If they have investable assets, meaning securities, it may be better just to do it at the brokerage account. Maybe you can do it multiple. You can open, it's like an estate account. It's going to issue a tax ID for the estate. So you can open a bank account and a brokerage account. It doesn't, you can have both.
Correct.
It's just in the name of,
that's
just
right.
like a trust or a person, you can open the same type of, the same titling of the account with tax ID at two different places.
That's right. And especially with a large estate, obviously it's going to be better off invested in a brokerage account. But it's good to have a checking account too. If you've got fees to pay here and there, it's all related to the estate, right? Once those are all paid off, then it's time to distribute assets per whatever the will says. And there's also executors are entitled to compensation by Georgia statute unless it's overridden in the will or by some separate agreement. Executors are entitled to 2.5% of whatever comes into the estate and 2.5% of what comes out of the estate. It doesn't always
I've seen
match
a lot
up,
of family members that don't charge.
They don't.
It.
Yes, a lot of times when the executor is also a beneficiary, one, they don't feel like they should be taking compensation, and two, if you take compensation, that's income tax on that. So it doesn't make sense sometimes. Why would you be paying income tax on something that you're going to get anyway?
Yeah.
And your inheritances you're not going to be at least in Georgia, there's only a few states that have inheritance tax to the recipient. But in Georgia, you get something. There's no income tax that you have to pay on that.
Yeah.
But if you're taking a commission as executor, that would be income that you would have to, pay taxes at your ordinary income tax rate on.
Yeah, I mean, the only tax I can think of as an inheritance, if you have like an inherited IRA, like that tax still stays there if you're taking IRA distributions, obviously, but not inheritance tax.
Yes, that's
in
right.
the sense of
That's
I
right.
got this money and so I'm paying tax on it.
No,
I just wanted to clarify just because that can be somewhat confusing. It's like, wait, I thought I had to pay taxes on the IRA, and you do as an IRA distribution, which is a totally different type of tax.
That's a good point. The IRS, if you funded an IRA and you put it in there tax free to get it out in some way, shape, or form, there's going to be a tax consequence. You're not going to avoid that because it happened through a will. But generally speaking, non-retirement accounts that are non-Roth, you're not going to get that. You're not going to get that
exactly.
That consequence.
So it's like when you're distributing assets. So it's like anything that's going through the will would go to the estate account and then to the beneficiaries named in the will after everything's settled and the debts are paid and all of that. If you have a trust account, same concept, it'll go by trust language versus a will.
Correct.
And then if you have a beneficiary of retirement accounts, life insurance, whoever the named beneficiary is on there, it'll go to them directly from those accounts.
That's right. And, for the estate tax limit right now is the highest it's basically ever been. It's $15 million right now. And when I say estate tax, I mean the federal estate tax. So if your estate is valued at over that amount, the estate pays 40% on the overage on that, and that's due 9 months after the date of death. Most of the time, especially with the limit so high, that's not going to apply. It's not as much of a forefront of planning as it used to be. All of that being said, things change. New administration can make up whatever they want down the road, but right now it is scheduled to continue to rise for inflation until basically it doesn't.
And that's a great segue into just talking about, the taxes. You obviously $15 million per person is the estate tax. There's 12 states that have inheritance tax to the beneficiaries or estate tax, but most states do not. So you can always check. They can always check on the website. Search for the states that have estate tax or inheritance tax just to see. One of the other, I don't want to say benefits to passing away because there's not a benefit, but one of the tax benefits is the step up in cost basis.
Yes, that's a good point.
Real estate, on brokerage assets. So it's eliminating those unrealized capital gains.
Yes, and a lot of times people will say, "Oh, I'm just going to deed my home to my child so they don't have to go through probate when I pass away." And if they live much longer, and that situation happens that the child gets it. Well, if they had just gotten it, the whole thing, when the person passed away, they would be in a better tax situation because when they turn around and sell that property, their basis would be higher, theoretically speaking, as long as the
so if a parent bought a home for $300,000 and let's say it grew to $700,000, so there's an unrealized gain of like $400,000 there, right? So if you're like, okay, first of all, there's so many issues with this.
Yes.
So it's like I'm gonna gift this house, a $700,000 house to my child, so it avoids probate, makes it simple. It goes to them now. That cost basis, that $300,000 stays with the gift recipient. Yeah. So if you gift somebody something, that is what your cost basis is their cost basis,
correct,
right? Where then there's just transfer tax issues because now you're going against the lifetime exemption, which is the $15 million, but you still have to file that. There's if somebody needs care and runs out of assets, Medicaid is going to say, did you transfer something in the last 5 years? I believe 5 years to look back. I'm pretty sure about that. So I always get the 3 and 5 year. I believe it's 5 years as a look back. And so, that could be an issue. So there's so many issues surrounding that where if you just held onto the property, or I've seen it where somebody sells the property thinking it'll be simpler. And then they pay, you get a $250,000 exclusion, but that was a $400,000 gain. So now you paid capital gains tax on $150,000, where if you just held this property until the person passed away, then they get a step up in cost basis, meaning that $300,000 cost goes to now $700,000.
Yeah, and you're bringing up a lot of good points. It's sometimes doing nothing actually is better for you and every other person. And when I say nothing, I mean not doing the thing that you think is better off. I think really the advice is, before you make these types of decisions or thinking about doing them or not doing them, do your research and then talk to somebody that is a professional and get their opinion on it. And they'll let you know, hey, this is okay that you do this, or you're opening up a can of worms if you do this. Do not do it.
Right.
And that probably goes for a lot of financial decisions, right? If you're unsure, if you think something is somewhat tricky and it's not in your wheelhouse, do your research.
Because sometimes there's just those little nuances
Yes.
that are,
so
I've
many.
seen so many tax things happen.
So
that I
many.
was like, could have been, but you can't take it back once it's done.
And
So
the IRS is a mess right now. You probably could get away with a whole lot of stuff right now, but you don't want to play that game.
No, definitely not. So really, we've talked about a lot of the mistakes to avoid, updating beneficiaries, just doing planning in general. We've talked about making it easier for loved ones, making sure that, the documents are in order, that the titling of the accounts is in order, your beneficiaries is in order, just to make sure that, to help avoid conflicts, and maybe even sitting down and talking to your family about your wishes.
Yeah, the communication part, I think, is big. If you've kept everybody in the dark, not only beyond the surprises for what they have to deal with, you may have not communicated something that was very important in order for things to be smooth. So you don't have to tell everybody everything, but it's a good idea to at least tell the people that are going to be in charge, I've updated my documents.
Mm-hmm.
Here's a contact person that you can speak with about it. You're in your own words, things to do, not do. If an attorney prepped these documents for you, they can help you with memos telling you, how to handle post-death, and written in the form of, hey, a memo to kids, to financial advisors. Basically, take care of that.
Yeah.
It goes a long way.
Absolutely. If 70% of people aren't prepared, then chances are that someone even your parents may not be, and starting this conversation. So, really start the conversation.
Yes.
Create update your estate plan, check your beneficiaries, but also, if you're close with family or loved ones, especially if you hear of one of them getting ill, just mention it to them maybe if you can.
I think, and again, whether you hire an attorney, that first conference that you have with them where you spit out all the info, that's really the hard work. The rest is putting everything together. And hey, if you don't want to go through an attorney, sometimes a legal Zoom will is at least better than not having anything in place. So just giving it some level of attention, even if it's just reading about something, there's probably going to be a light bulb that goes off, and some action is probably going to be taken to, make a situation better than it would have been otherwise.
Absolutely. Thank you for always coming on and talking about these such important matters.
Yes.
If anyone wants to reach you, we have your contact information in the show notes, as well as a couple other videos, and podcasts in there about digital estate planning and then simple estate planning errors that I think will be helpful. But always glad to have you on here, and work together and through estates and planning and all of that. So I appreciate you coming today.
I love coming on here. And again, there's no perfect plan. You can't predict the future, but just talking about these things goes a really, really long way. I want to stress that.
Absolutely. Thank you, Aaron. Thanks for listening to today's episode. If you're interested in learning more about Wiser Wealth Management or want to schedule a consultation to meet with one of our fiduciary financial advisors, you can do so by going to wiserinvestor.com, or you can click on the link in the episode notes. We'll see you next week.
Thanks for listening to a Wiser Retirement podcast. We hope you enjoyed today's episode. Make sure to subscribe wherever you're listening. That way you don't miss any new episodes. We'd also appreciate if you could leave a rating and review. If you have any questions about anything that was discussed today, head to wiserinvestor.com and reach out. This podcast is strictly for informational purposes only and is not to be considered as investment advice or solicitation to buy or sell any financial products, securities, digital assets, or any other investment vehicles, or a basis to make any financial decisions. Wiser Wealth Management Incorporated is a registered investor advisor with the SEC. The host and/or guests may personally own securities, digital assets, or other investment vehicles mentioned on this podcast. Neither the host nor guests of the show are compensated for their participation, and no referral fees are paid to or received by any host or guest for clients, listeners, or similar interests. Investments involve risk, and unless otherwise stated, are not guaranteed. Be sure to first consult with a qualified financial advisor, tax professional, insurance professional, and/or legal professional before implementing any strategy discussed herein. Past performance is not indicative of future performance.